What's up, everybody? This is a video I can't wait to do. We are going to read the judge's order forcing Sarah Boone to represent herself. We'll figure out why he did it, why he finally said enough is officially enough. She has forfeited her right to be appointed counsel. Do you know how hard that is to do? She's one of a kind, unlike any other, dealing with a situation like this. And I can promise you, I know this judge, he did not take this lightly. He did not do this flippantly. I have not read this order yet. The first time I'm going to read it is with you. You're going to get my instant reaction, but I can't wait to see what he said and why and how we got here. Let me know what you think in the comments as we go, and if you think he stepped too far too fast, or if you agree with it. So let's get to it. We're going to read this order together. If you guys have not subscribed to our channel and you're following the Sarah Boone case, make sure you subscribe and hit that reminder bell. Check out our Sarah Boone playlist. We've got a ton of videos on it. We've been following it from the jump. We've watched her interrogation. We've watched everything there is to watch on this case as far as I know. And I'm sure there'll be some comments about my shirt. Feeling very patriotic today. We were by the pool. Got an American flag type bathing suit on. And of course, got to match it all the way up. So hit that like button and let's get started here. This cause came before the court on June 28th on defense counsel Patricia A. Cashman's motion to withdraw, filed June 11th. We watched that hearing together. We heard what the lawyer said. I said, if I were the judge, I'd say, this is it, Sarah, one shot. And if you get rid of this lawyer, you are choosing to represent yourself. Guess what? He didn't do that. He said he's reviewed the court file. He reviewed the audio transcripts from various hearings. So he's gone back. He's done his research. This is a very smart judge. Having considered the positions offered by counsel Patricia Cashman, having considered the testimony of defendant Sarah Boone, and having considered the positions offered by counsel for the state, the court finds this. Here are the charges on March 23rd, 2020. Again, 4+ years ago. The defendant was charged with second-degree murder. Procedural history. On February 22nd, the Office of the Public Defender in and for Orange County was appointed to represent the defendant. On March 9th, the public defender moved to withdraw due to the defendant retaining private counsel, Mauricio Padilla. On March 11th, the order allowing withdrawal was entered, which withdrew from the public defender from further representation. On April 18th, Padilla moved to withdraw due to irreconcilable differences. So the first withdrawal from the public defender, not her fault. Second withdrawal, irreconcilable differences. You could at least argue it's her fault. We don't know specifically what that was. But he said that between him and the defendant, it made it impossible for them to continue to effectively represent her. As always, it is difficult to convey all the particulars to the court and at the same time maintain all duties to the client. The motion was served upon the defendant, and the defendant confirmed receipt, and he attaches the letter. So he's saying irreconcilable differences 2 years into representing her, right? Because on March of 2020, the first public defender was out, Padilla was in, and then April, 2 years later of 2022, he was out after 2 years of being private counsel. Irreconcilable differences. You can't always say why, but it's a little wink, wink to the court, like it ain't working, judge. At the hearing, Padilla said that he'd been representing her for 2 years. The court advised Padilla that the court had received a letter from the defendant, which seemingly objected to Padilla's withdrawal. The court advised Padilla that the options were to not proceed on Padilla's motion to withdraw or provide the court more about the irreconcilable differences. They want to dig in more to that. Padilla requested an opportunity to amend the motion to withdraw, to prepare and file amended motion with a hearing to be heard. The state advised of Padilla's diligence and representation. The state advised of Padilla's diligence in preparation, and the court commended Padilla's work. Defendant testified to a lack of trust between herself and Padilla. There's going to be a common theme here in this order. But her private chosen counsel couldn't work with her. The state said he did a good job. The court said he did a good job. And the defendant, Sarah Boone, said she doesn't trust him. That was probably her biggest mistake in the case. On May 4th, he filed his amended motion to withdraw. And it said, undersigned's relationship with defendant has become adversarial. Sound familiar? The aforementioned adversarial relationship has interfered with undersigned counsel's ability to effectively represent his client, especially preparing for trial. Undersigned appreciates the court providing him the opportunity to amend his previously filed motion to withdraw. However, after further researching the issue, undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client, and as such will stand mute on the specifics. So he's saying, if I were to tell you what the major issue was, that could create an issue for Sarah Boone. We don't want to do that because even though we want to withdraw as her attorney, I don't want to hurt her case. I still want to do what's best for the client. So, respectable. On May 6th, Padilla filed a second amended motion which further supplemented the original. Undersigned relationship with the defendant has deteriorated to a point where undersigned counsel can no longer give effective aid in the fair representation of Ms. Boone's defense. This motion is in compliance with Florida Rule of Judicial Administration 2.505F1 and Rule 41.16B. Rules regulating the Florida bar are present, or whether an attorney-client relationship has deteriorated to a point where counsel can no longer give effective aid in their fair presentation of a defense. On May 10, 2022, a hearing was held on Padilla's second motion to withdraw. The defendant was present for the hearing and was sworn. Padilla advised the court that he had no other choice but to file the motion to withdraw due to ethical concerns. Defendant confirmed that she wanted to terminate Padilla as her attorney. The state expressed concern of a strategy to allow the defense attorney after attorney to allow defense attorney after defense attorney to represent the defendant. Okay, so this is way back in May of 2022, after just her second lawyer. A strategy of the defendant being unhappy with every attorney and advised the defendant about the danger of self-representation. The court appointed the public defender, attorney number 3. On June 6th, public defender moved to withdraw due to a conflict. So that's May to June, 1 month, conflict, not her fault. So far we have 1 that is her fault, 2 that are not her fault. We've done this before, by the way. On June 7th, the court allowed the public defender to withdraw and appointed conflict counsel. Okay, that's how we get people outside the public defender's office, because she's conflicted within the public defender's office. I think it was because the victim was also represented by the public defender's office, but I'm not positive of what that conflict was. Either way, we get to attorney number 4. On June 10th, RCC moved to withdraw due to a conflict. Okay, so regional counsel also moved to withdraw because of a conflict. So attorney number 4, also not her fault. So 1 so far is her fault, 3 are not her fault. On June 22nd, that's an order allowing conflict counsel to withdraw was entered. On July 8th, the Consalo moved to withdraw due to a conflict. Sorry. Okay, so then appointed Mark Consalo. Sorry, number 5. Also moved to withdraw because of a conflict. Again, not her fault. 4 not her fault. 1 that is her fault. On July 11th, it was ordered, and Bankowitz was appointed. So Bankowitz in open court requested a continuance. Court set a pretrial conference. During the pretrial conference, November 7th, and a trial during the trial period, November 7th. October 25th, the court held a pretrial conference and addressed the court's understanding that a continuance was being sought, and the court's JA was to reach out to the parties. Bankowitz filed another motion to continue. The court entered that certain amended order on the defendant's stipulated motion to continue, which set the pretrial conference for January 17th. On November 22nd, the court set a status hearing on December 20th. On December 19th, Bankowitz moved to withdraw. And we know while all this was happening, she's writing a bunch of letters to the court saying how horrible Bankowitz is. He's not answering his phone. His phone's not even turned on. He's not talking to her. He's not answering her. He's horrible. She needs a better lawyer this whole time. The irreconcilable differences in his motion to withdraw had arisen between the undersigned and his client and his family. And the undersigned will be unable to effectively and properly continue representing the defendant herein. On December 20th, status hearing was held. Bankowitz did not appear due to a car accident. I didn't know it was a car accident. I knew something happened. Court reset it for December 22nd. December 22nd, reset the status of the hearing. Bankowitz appeared virtually due to technical issues. Bankowitz was unable to hear the court. The court reset it again to December 27th. We remember when all this was happening. And it was kind of feeding into what Sarah Boone was saying about Bankowitz and some other issues with Bankowitz. Hearing was held on Bankowitz's motion. The defendant was present. The court advised the defendant that the court had received letters from the defendant, which we read. The court conducted a Nelson hearing where the defendant was not seeking to remove Bankowitz. Bankowitz advised the court of the thousands of pages of discovery that he had reviewed and organized in his contact and potential use of and collaboration with expert witnesses, including experts that Padilla utilized, which was attorney number 2. Banquets advised the court. By the way, this paragraph right here says to me, the court laying the foundation that Banquets actually did do work on the case and didn't just do nothing over the months that he represented her. Banquets advised the court of defendants' attempts to call Banquets at a rate of 5 to 10 times a day. Banquets further advised of his efforts to balance the demands of other clients and the defendant's expectations for communication. In response, the defendant reposited that Banquets' representations were untruths, again, calling him a liar. It's always bad to call your lawyer a liar and then say you want him to keep representing you. Raised Banquets' prior public reprimands for lack of communication. Alleged Banquets' action in this case rose to a similar level and then sought to remove Banquets. The court pointed out defendants' inconsistent statements within 10 minutes of them being made and addressed concern over defendants' motivations, especially when there is something defendant disagreed with. The court specifically advised defendant that she is not entitled to an endless line of court-appointed lawyers until you find the one. By the way, this is only the second one that's going to be at least partially her fault. So let's remember that. Endless line. So far, it's been 2. And you don't get a lawyer you personally prefer. The court also explained the circumstances where defendant could represent herself. Ultimately, defendant did not request to remove Banquets. The court denied Banquets' motion to withdraw and directed Banquets to have a conference with the defendant prior to the pretrial conference on January 17th. Case continued several times due to Banquets' attempt to retain an expert through JAC and JAC response, and we knew they were trying to get money for those experts. During this time period, the court had received several letters from the defendant, and he puts all the dates from all the letters from the defendant. Again, we know about those letters. On August 22nd, Banquets again moved to withdraw. Irreconcilable differences arising between undersigned and the defendant that have made it impossible for undersigned to effectively represent his client. As always, it is difficult to convey all the particulars to the court at the same time, maintain all duties to the client. Again, very similar letters to prior counsel's motion to withdraw. The defendant will not be satisfied with any attorney unless said attorney does not have a caseload and can dedicate his or her time solely to Ms. Boone's case. The best possible avenue is to have the defendant represent herself, as no attorney can satisfy her. That's Banquets' opinion. On September 8th, a hearing was held on Banquets' motion to withdraw. The defendant was present for the hearing and was sworn. Banquets addressed the defendant's derogatory statements. She called him a dud and a buffoon and berating behavior. The court advised the defendant that the court had received letters from the defendant. After the court's colloquy of the defendant and her acquiescence to Banquets' withdrawal, the court granted Banquets' motion to withdraw and appointed Winston Hobson. Attorney number 7, but again, 2 were her fault, or at least partially her fault or her choice. 4 were not so far. Now we're on attorney number 7. By the way, Banquets is the only one that we have seen that if any legitimate concerns arise that he didn't necessarily disagree with was some of the lack of communication. He said she wanted too much. She said he wasn't giving her any at all. Somewhere in the middle was probably the truth, or where it should have been as far as communication goes. But eventually, after 2 attempts to withdraw, one time Sarah Boone didn't want it, second time she did, Banquets was allowed off the case. Thereafter, the court set a status conference in October, pretrial conference in November. After setting these dates, the court pointed out the deterioration of the working relationship between defendant and Banquets. Court further cautioned that if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. Court further advised that there are certain decisions the attorney gets to make and certain decisions that a defendant gets to make. The court cautioned the defendant that unrealistic expectations regarding court-appointed counsel and reminded the attorney of her right to retain private counsel. So again, we remember back when Winston was appointed, the warnings start to get more serious and stern. On October 30th, status conference was held. Hobson advised as to his conversation with the defendant and setting a status January 2024. Court set a pretrial conference, status as to the readiness for trial. Hobson filed a motion to continue, waiver of presence, and requested 3 docket continuance. A 3 docket continuance, which was like 3 months. Court addressed Hobson's motion to continue, granted it. February, Hobson moved to withdraw. Okay, just a couple months after representing her. Irreconcilable differences, including but not limited to ethical considerations. Very similar issues with Sarah Boone that the 2 prior attorneys that were not just conflicted off had. February 9th, hearing was held. Hobson addressed a number of issues, asked for the basis of withdrawing, including disagreements on legal strategy. on what can and cannot be done and lack of resources. And the defendant's demands make her difficult to work with, including defendant taking non-viable legal positions and being unreasonable. So now we're getting more specific, but the issues are all dealing with what she expects and what she wants to do and how much communication she wants to have and how much say she wants to have in her legal strategy, especially when it comes to non-viable legal positions. Because I think that's something Cashman, attorney number 8, also complained about. As to key substantive defenses, Hobson advised that they retain an undisclosed expert is not keeping with what the defendant has in mind. So the expert isn't agreeing with what the defendant wants either. We see a common theme here. That usually means the defendant says, I want this legal defense, and the lawyer and the expert's like, that's not possible based on the facts and what we have in this case. The court outlined the overriding claims for withdrawal by Padilla, Bankowitz, and Hobson, adversarial relationships, lack of satisfaction, inability to meet defendant's desires. The court found that all the defendant's relationships with all the court-appointed counsels have deteriorated such that the defendant and the court-appointed counsel cannot work together. The court advised the defendant that although the defendant has a right to court-appointed counsel, it's not unlimited. The court twice advised the defendant that the defendant may not be provided another court-appointed counsel and that the defendant would have to represent herself if circumstances similar to Hobson's motion to withdraw occur. The court further advised the defendant about the dangers of self-representation due to the defendant's lack of legal training and knowledge. So again, we remember this when he advised her of this. And again, to me, that's a scary proposition because you're telling her that's dangerous and it's basically bad for you right before you appoint this attorney Cashman. Defendant never stated that she did not understand that she may not be provided another court-appointed attorney. So we listened to it. We saw it. He definitely warned her. One of the things I would have done again after Cashman is say, this is the last one and make it black and white clear. I feel like she was absolutely warned by this judge, but maybe I'm being too soft on Sarah Boone by saying I would have given her one more and tried to just lay it down in writing. This is the last one. It seems to me like the court believes and feels like he did it last time before appointing Cashman. He granted Hobson's motion to withdraw. Now it's 3 that are at least partially Sarah Boone's fault, 4 that are not out of those 7. And we get to lawyer number 8, which is Cashman. Court is aware of Cashman's extensive experience representing criminal defendants as both an assistant public defender and in private practice, including represented defendants accused of murder, and is widely known to be able and willing to deal with and manage difficult clients. Hey, how about that? Her reputation precedes her, and we dug into that, and we would agree with the court. April 12th status hearing. Cashman advised depositions that have been set, hiring of an expert, requested further status. June 7th status hearing was held. Cashman addressed her dates of availability for trial. Defendant was present. Thereafter, the defendant advised the court to walking out of multiple meetings with Cashman, which was confirmed by Cashman, utilizing a pretend judge to oversee the defendant and Cashman, launching multiple attacks on Cashman's professionalism, and providing the court with letters dated June 4th and June 7th, both of which were filed in the court file on June 21st. We read it. Last video. If you want to see what that letter said, 58 pages long, check out the last video. Cashman advised to her efforts and time spent on the case so far, 20 hours. Cashman addressed disagreements on legal strategy, including defendants attaching importance to issues that may not be legally important. What does that sound like? Exactly what Hobson said. Defendant accused Cashman of lies and half-truths. On June 11th, Cashman moved to withdraw under Florida rule regulating Florida Bar 417B2. Substantial risk that representation of one or more clients will be material limited by the lawyer's representation to another client. That's interesting. I would like to know what she specifically means by that. And of course, irreconcilable differences, including but not limited to ethical considerations, have arisen such that counsel can no longer provide representations, which is right in line with the other 3 that were at least Sarah Boone's fault partially. So now we have 4 lawyers that are bouncing because of Sarah Boone, at least partially, and 4 that were conflicted off, making 8 total, which is a ton. But there have been clients with 4, not 8, but 4. So we're kind of in that area where it's horrible, bad, much worse than normal, but not necessarily as bad as it sounds when we hear lawyer number 8. On June 28th, a hearing was held. Cashman was moved to withdraw. Cashman relied on the Florida Bar rules for the basis of withdrawal. At no time has defendant refused to accept the services of any of her 7 appointed attorneys. Saying 7 again and calling it lawyer number 8, number 9 is worse than it really is. Sounds worse than it really is. It's bad, but it sounds even worse. let's get to the law here. Both the United States and Florida Constitution guarantee an indigent criminal defendant the right to assistance of appointed counsel. The counsel clause of the Florida Constitution under Article 1, Section 16 recognizes the right to counsel as well as self-representation in all criminal prosecutions. Let's get to what it says about forfeiture of the right to counsel. And I will say, I have not come across a case where this has been done. So this will be really interesting. Obviously, it's outside my purview. I'm not a public defender. I'm not conflict counsel. Nobody in my firm is. So it's a little outside our purview to be dealing with these rules, but I'm very interested in it because anything that's novel and new and different is very interesting to me. A defendant in a criminal case can forfeit a right to court-appointed counsel. A forfeiture is an extreme measure that flows from the defendant's abuse or manipulation of the right to counsel and results in the defendant being required to represent himself or herself, even though he has not waived counsel and may still want legal representation. So this is important. We need to pause here for a second and focus on the fact that this is an absolutely extreme measure. We do not want this to become the norm. We do not want people representing themselves. We always warn against it. We always tell how bad it is. We always say, and just like the court warned Sarah Boone before, it's dangerous. You have no legal training. You have no background. You have no experience. Your other lawyers are calling what you want to do in the case non-viable and not legitimate or substantial arguments that you should even be able to make or ever make at trial. So if that's an indication as to how she's going to do representing herself, it's not going to be good. So this is absolutely an extreme and ill-advised measure to forfeit or waive your right to counsel. And it's especially extreme when she doesn't want to waive that right and she's not choosing to represent herself like somebody like Darrell Brooks, who waived his right and chose to represent himself. Forfeiture is a judicial response that adapts the course of legal proceedings to the defendant's choice to engage in misconduct that undermines the legitimate exercise of the right to counsel. So again, she has to abuse or manipulate the right to counsel. Do you think she's done that? Let me know in the comments. We know she's called her lawyers names, called them duds, said they've told lies. She's made misrepresentations about reviewing certain documents, and then later we see her notes on those documents. She's written letters to the court going outside her relationship with counsel, violating and kind of waiving the privilege that is in fact hers, trying to make them look bad, trying to hurt their careers, publicly doing this, being disrespectful, calling them names, calling them snotty. Is that abuse? And she's figured out by now, every time she gets a new lawyer, it causes delay. Does she want those delays? Is she being manipulative? Is she abusing the process, trying to garner fame and notoriety? Those are legitimate concerns, I think. We'll see what the court says here. As set forth above, the defendant's recalcitrance to the attorneys who were not conflicted out, Padilla, Bankiewicz, Hobson, Cashman, so that's 4, antagonism, hostility, and attacks on the professionalism of Padilla over a year after the fact, see footnote 9, of Bankiewicz and of Cashman, and the personal attacks on Padilla, Bankiewicz, and Cashman, each of these attorneys were required to withdraw. It has become apparent to the court that the defendant will not permit herself to be represented by anyone. Guess what? That's what Bankiewicz said as well. Additionally, the withdrawal of 8 different attorneys, 7 of which were court-appointed, leads to a determination that the defendant has forfeited his right to counsel. I think he means her right to counsel. Under Florida law, the facts at bar amount to a binding forfeiture of the right to counsel. As the court finds, the defendant has forfeited the right to court-appointed counsel. Under Florida law, there is no obligation to conduct a Feretta hearing or to otherwise warn a defendant of the dangers of proceeding pro se. So if you want to know what a Feretta hearing is, go back and watch Darrell Brooks. That's the judge basically over and over again being like, are you sure? Do you really want to do this? Do you know what you're waiving? Once you waive, you can't go back. We're not going to let you have a lawyer go in and out. Are you sure you want to do this? He's like, we don't even have to do that. Her actions have forced my hand, She's forfeited the right to counsel. This is extreme, folks. This is not something a judge does lightly. So let's look into what he says the conduct is that forces this forfeiture and waiver. The court can find a waiver by conduct to the right to counsel. A waiver by conduct requires that a defendant be warned about the consequences of his conduct, including the risks of proceeding pro se. So a lot of these sites are going to say his, because that's what's quoted in the case law, because the defendant was a he in the case, but they can also obviously apply to Sarah Boone. On February 9th, the defendant was twice advised that another court-appointed attorney may not be provided. And that's one of the only issues I have with all this. I agree with the court. I think there are major issues with Sarah Boone. But I would have been unequivocal in this last-ditch effort to say they will not be provided if you blow this one. If you piss them off, if you're disrespectful, if you don't agree with their legal strategy, there will not be another. And then I would have given her the very last one. He said that may not be provided, which kind of left the door open. I'm quibbling, though. I understand why and how he got here. The defendant was advised about the dangers of representing herself in May 22. The defendant was advised about the dangers of representing herself again in February of 24. As of February 24, the instant case had been continued 16 times. That's a lot. We talked in Koberger. It's been a year. They're going to try the case in 2 years. That's about average. So 4 years is twice the average. The case has been pending for 4 years, 3 months, and 5 days. That's interesting. Is that a little wink, wink to Sarah Boone, who likes to put the days, hours, minutes, years, months that she's been waiting or that something's happened? I don't know. But I believe this court has read every one of Sarah Boone's letters in this case. I believe he's gone back, watched the prior hearings, read everything to make sure that he does not take this forfeiture lightly and this decision that he has felt that Sarah Boone's actions has forced him into. He doesn't take them lightly. Actions speak louder than words. Another, to me, hit to her letters and the comments she's making. Her actions are more important than those words. Although defendant's words seemingly reveal a desire to go to trial, because she keeps saying it. I believed her at first. But as time has gone by, even I have started to say, does she like these continuances? Does she like people reading her letters? Does she like where she's at? Does she know she's going to end up there anyways? Does she know she's going to end up with time served? So it doesn't matter how long it takes because all this is going to be counted toward her sentence. However, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over, allowing the defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage the defendant to persist in efforts to prevent the resolution of the case on its merits, the concept of which was first brought to defendant's attention in May of 2020. So 2 years ago, she was told, this may be the end of the line for you. Then a couple months ago, again, this may not happen again. You may not get another lawyer. Well, the defendant complains that Bankowitz and Hobson, 2 court-appointed attorneys, failed to meet and communicate. And when defendant is provided a court-appointed counsel who will meet and communicate Cashman, the ways and means of the meeting and communicating are unacceptable. That's why Cashman was so important. That's why her digging in immediately and getting so much done in a short period of time, meeting with her for 20 hours, reviewing all this, setting depots, getting experts, showing that she's the one. She can deal with this difficult client. Boone still finds an issue. She calls her snotty. That's subjective. Not meeting with Boone, if she could prove that, that would be an objective complaint. A complaint that may be legitimate. I'm not saying it is, but it may be legitimate. And at the time we said, if he's really not answering her calls and never meeting with her, never talking to her, that is not right. That is not justice. That is not zealously representing your client. We can say it's lies. We don't know if it's true. I'm saying if it was true, it was a problem. That's always what I said. If it was true, and if it's not true, I wish he would have pushed back a little bit more, because it doesn't violate privilege to say I absolutely met with her judge. I talked to her for this long on these different dates. I did pick up the phone. I have logs of when I met with her, but we didn't get any of that. You know who did do that? Cashman. And this judge very astutely said, some of the legitimate complaints, fine. You're going to find something to complain about everybody, which is proven by Cashman, who did meet with you, but you didn't like the way she met with you or the way she spoke to you. That's proof enough for me, the judge said, that you're going to find a problem. And if I appoint somebody else, it'll be the color of their hair or how quickly they speak to you or how often they call you or show up, or they won't call this witness or that. We haven't even really gotten very far into trial prep. How do you think that would go with Sarah Boone, with one of these lawyers? How do you think she would like them telling her what the strategy is going to be and what the questions are going to be that they ask? So the judge is saying, with how hands-on she's being, how much she's complaining about everybody. The only person that's going to represent her case and do it the way she wants it is her. Ooh, that's not good. Under Florida law, the facts at bar amount to a binding waiver of the right to counsel. So what happens from here and how Sarah Boone acts is going to be very important. We'll talk about that after we read this. All right, what is the order? Cashman's motion to withdraw is granted. As a condition, Cashman shall provide the court an order for costs to obtain transcripts of deposition for the two witnesses Cashman deposed. Upon completion of the transcription of the depositions, the deposition transcripts shall be sent directly to defendant. She wants all her discovery. By golly, she's going to get it now. Thereafter, Cashman shall file a notice with the court reflecting that deposition transcripts were provided to the defendant, Sarah Boone, as such, and such notice shall include the date sent and the address for Sarah Boone. We know where that is. The defendant has forfeited her right to appointed counsel. The defendant has waived by her conduct her right to court-appointed counsel. The trial management conference shall remain specially set for Tuesday, September 24th, 2024. We're pushing ahead to trial, folks. This case shall remain specially set for trial for the 2-week period beginning Monday, October 7th. My guess is if she really, well, we'll talk about that after. It will not be continued for any reason except by extraordinarily good cause, and such extraordinarily good cause shall not include retention of counsel by defendant. So she can still go hire her own lawyer, folks. She can still pay her own private lawyer. That is not going to be stripped from her. Any and all pretrial motion on this case must be filed no later than the close of business on Monday, July 22nd, 2024. And guess what? She'll be at every conference now. She'll be at every hearing now. In the certificate of service, he's going to make sure Sarah Boone gets this. What does it say? Sarah Boone via hand delivery. This is going to be hand delivered to her. So what does she do now? Let's talk about that for a second. Number one, she can make this very difficult on the court. If she refuses to say anything, refuses to represent herself, refuses to call witnesses, refuses to cross-examine witnesses, and saying, I never waived my right. That puts the judge in a difficult spot. I think I know what the judge will do. I think he'll have colloquies. I think he'll advise her of things on the record. I think he'll give her chances and her refusal is, again, a waiver. Her refusal to ask questions is a waiver of her right to cross-examine witnesses and confront witnesses. So if she really is difficult, the judge will handle it appropriately. And he'll say it's a waiver. But again, I still think that's difficult to deal with as a judge. But what she can do is dig in, look at the discovery, read everything, watch everything, prepare to cross-examine witnesses. She's got the time. She's told us how smart and intelligent and well-versed she is and well-spoken. She knows how to make an argument. We saw her arguing and trying to convince the cops that she was innocent. Now she'll be able to do it to a jury. So we know she has the capability, at least as a human being, to do it, maybe not as a lawyer. But Sarah Boone, whether she likes it or not, is lawyer number 9. She's lawyer number 9. She's going to take this case on. She's going to represent herself, whether she likes it or not. And I do believe that while the court said he will only continue the case for extraordinary circumstances, I think if she digs in, she does her best, she wants to get an expert, she wants to depose a witness. Some people pro se have done that. If she really tries and she tells the court, I need more time, I think the court will give it to her. If she doesn't do anything and she just shows up and asks for a continuance, he's going to deny it, which is crazy to think that this trial could actually happen in October of this year, less than 4 months away, right? We've got July, August, September, October. This could be happening, folks. And we know we have at least one more hearing in September. What will she be able to get done between now and then? There are going to be all sorts of appellate issues. I will just tell you. Court-appointed appellate counsel that's coming after she loses, because now the chances of her losing are much higher now that she's representing herself. This will be an appellate issue. That's why he very thoroughly went through the record, put everything down in black and white. He says by her fault and manipulation, abuse of the process, these 4 lawyers were out, 4 others conflicted off. So that creates an issue with the public defender's office as well, which limits the amount of lawyers that can really be appointed for her. And now she's going to represent herself. There's no issues with competency. So we don't have that battle like we had in Darrell Brooks potentially. How difficult will she be with the judge? I don't expect her to be like Darrell Brooks, but I expect her to be offended by certain things the judge does. Think she's not being treated fairly or respectfully, I'm sure, or that he's limiting her capability. She's going to want to ask questions or call witnesses that she doesn't have the ability to call, or legally she's not going to be able to do. She's going to want to enter evidence that she's not legally able to. She's going to for sure want to ask about hearsay or talk about irrelevant character evidence about the victim, maybe the victim's families. I can foresee some of those things happening. And we'll save it in future videos. We'll talk about exactly how she thinks she's going to handle this. Do you think the judge made the right call? Do you think Sarah Boone has been abusive and manipulative as part of the entire process? This is one of those videos. I cannot wait to read your comments. Make sure you guys hit the like button. Make sure you're subscribed to our page for more, because there will be more on this case. It's coming fast and furious now. Thanks, you guys, for joining me. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.